Yes, please, for the list.
Item number 1.
May it please your Lordship.
Yes.
Your Lordship, the state is in appeal against the order of learned single judge. The order of
Yes.
the order of learned single judge has resulted in quashing of.
Yes.
Yes, my lord. The learned single judge has quashed the order of state government, whereby the toll gate set up by local sirdar for collection of toll from trucks passing through the area has been quashed, my lord. So this order, my lord, it was earlier part heard. We have filed the compilation in this matter, my lord. If lordship, because there is some difficulty from the respondent side, my lord, the learned senior counsel for the respondent is on sanctioned leave. I was praying that if this matter can be listed for hearing next week, anytime next week, physically I will come and argue this matter, my lord. I will.
Can we fix it on Monday, sir?
Yeah, your lordship may have it on Monday, lordship.
Okay. Because this bench will be sitting on Monday, so we
Yes,
can.
my lord. I'll.
But can you tell us in short what is the matter, please?
The matter is, my lord, that there is a sirdarship under the ilaka of KHADC. This is called ilaka is Maulong. Ilaka is Maulong, where the sirdarship has set up toll gate.
Yes.
So a toll gate, and that toll gate is collecting the toll from the trucks passing through the ilaka. The case of the sirdarship is that it is entitled to collect customary toll from the trucks. Our state's case is, my lord, that this is a mineral laden trucks and entire matter is governed by MMDR Act, and also sirdars have no right to collect the tolls because it is also a violation of 19(1)G also.
So if I have understood your counsel properly, is this?
Yes,
there's a conflict between a statutory law and a customary law.
Yes, my lord. That is one aspect of the matter, my lord. And there is a judgment which has been relied by the learned single judge of the division bench of erstwhile Guwahati High Court. But my lord, that judgment says that no law has been brought to the notice of the division bench that the customary law, under the customary law, has been interfered, or some law has been passed through, under which the toll can be collected. So this is the sort issue which is before.
But collection of, I think, the toll tax, correct? These are all toll tax.
Yes, toll tax.
So these toll taxes should be governed by, subject to hearing you, madam, it should be governed by the laws which are prevailing here. So customary law, will it prevail over any statutory law?
May I please, your lordship?
Because customary law is basically restricted to any family things, family matters, or which are essentially private in nature. Essentially private in nature, but where the state is there, if there is a conflict between the state law and the customary law so far as the private rights are concerned, we may agree with you. But can a customary law give you a right to collect a toll tax, which is, because this toll tax are collected essentially, I think, for repairing of the roads of a public purpose. Am I correct?
Yes, my lord. Yes, my lord. In this case, it is the case of the sirdarship that.
So this appears to be a short issue on this. This is the only
Yes, my
issue.
lord. Yes, my lord.
So, madam, Monday is fine for you?
Yes, sir.
Your senior will be there?
Yes, Your Lordship.
Yes, my lord. Yes, my lord. Compilation and everything is filed, my lord. It was part heard earlier also, my lord.
Yes.
Please, Your Lordship.
You are for the appellant?
I'm for the respondent.
I'm for the appellant.
Yes.
Lordship, I pray for some accommodation in this matter as my learned seniors indisposed, Lordship.
So tell me when both of you will be ready.
After 2 weeks, Lordship.
2 weeks. Well, please put on the poster page. So you are
Respondent 1, 2, 3, and 4. 1 to 4.
and a prayer for adjournment is made on behalf of the here also the notes of argument and everything has been filed. Have you filed your written notes of argument?
We've not filed the written arguments
So
before.
please file your written notes of argument.
Lordship.
Parties are directed to file the written notes of argument within 1 week from date.
Number 5, Your Lordship.
So please
Number 3 and 4.
yes. Yes, 3 and 4. Who is for the appellants?
I'm for the appellant university, Your Lordship. Your Lordship, in this case, my lord, I'll just.
Your Lordship, I'm
New
appearing in this
versus
matter
new.
for.
Who's name is? New versus new. Huh? This order is transcribed under wrong cause title. This order is transcribed in. Oh, I see. Okay, okay. Sorry. It's my mistake. Yes. So you are for the university.
I'm for the university, Your Lordship.
And you are for the respondents.
Respondent, Your Lordship, I'm appearing on behalf of Mr. Manik Chanda. He's based in Guwahati. He's supposed to appear online, but some technical difficulties isn't able to appear. So, Your Lordship,
What does this matter?
Well, this is regarding, my lord, entitlement of three, my lord, financial upgradation. Three financial upgradation, my lord, of an employee of the non-teaching employee of the university. So our contention before the learned single judge was that all the three upgradation, because upgradation, my lord, those SCP, MSCP, my lord. SCP, MSCP normally, my lord, so far the university is concerned, my lord, it's a central university. These are, my lord, formulated by the central government. So these are not suo motu, this doesn't have any application in the university unless it is extended by the UGC. In fact, UGC extended this subject to certain conditions, my lord, that any upgradation otherwise also granted, that has to be adjusted. So after adjustment on all, my lord, we have given them all the...
I don't know whether it is relevant or not.
Lordship.
There was a three-judge-bench decision of the Calcutta High Court on touching on all these points on certain circulars. Some may be relevant, some may not be relevant.
Lordship.
So that you can
Look
the
into.
three-judge-bench decision. Justice Tandon was there, myself, and Justice Kaushik Chandra. But the judgment is delivered by me. So there we discuss some issues. So you might find some relevance there. And if it is of some assistance to you, you can look into it. And what is your opinion about the entitlement? If they have worked for so many years,
Lordship.
so financial upgradation, if they are otherwise entitled,
They should get it.
so why don't you look into this grievance?
Well, definitely. But here is a case, my lord. We have shown before the learned single judge, my lord, that all the three financial upgradation has been given.
Actually, they are saying that your case is that they have this has
Given,
been
given.
extended.
If they are entitled, they will have
What
it.
was the subject matter in the read?
Subject matter of the writ, my lord, that all the financial upgradations were not given. So,
But
stand
you
of
have-
the university.
But you have demonstrated that all things.
Yes.
Questions were given.
That's,
But still, then you lost the matter. The learned single judge was not satisfied that you. So there must be a finding that they did not get the financial benefits.
exactly, my lord.
Correct?
That's I have formulated a table, my lord, showing, my lord, how they
you
have and
given-
how and when they have.
Have you
worked.
filed your notes, please?
No, my lord. I'm not.
So both of you, please file your notes.
Not.
So when should we keep it?
Should be after 2 weeks. Lordship.
Maybe. अच्छा उन्होंने 2 weeks से पढ़ रही ना? Huh? On the prayer of the land council for the Yes, please.
Number 1.
Yes, please.
May I speak, Your Lordship? My Lord, by this review petition, my Lord, the petitioner is seeking to review the judgment and order dated 19th of August 2025 passed in the first appeal, by which statutory rate of interest on excess compensation awarded by the reference court was reduced from 9% and 15% to 6%. I can take your lordship to the judgment. My lord may turn.
This is due to act of acquisition.
Yes, my lord.
Yes, ma'am.
But here what happened, my lord, a portion of land was acquired through the collector, my lord, for the purpose of central government.
But grounds of review are very limited. The grounds of
Very
review.
limited.
Yes.
It's very.
But what is the error apparent on the face of the record?
Yes.
Where
yes,
is the
that's
error?
what I
Yes,
will-
yes, yes,
That's
yes.
what I will show. Your lordship will kindly come to page 63.
63.
Yeah, the impugned judgment starts from page 58,
Yes.
section 2.
63. Yes.
Yes, the relevant is 63. The last paragraph, my lord, last 2 lines starts from here. I find impugned judgment and order dated 20th of February 2024 to be a proper exercise of discretion and otherwise sound. There is no scope of any interference, save and except that considering the long period of interest payment and involvement of government revenue, the rate of interest at serial number 4 under the heading calculation at page 45 to 46 of the said judgment shall be at the uniform rate of 6% simple interest per annum. Now, my lord, the review is filed on the ground that, my lord, Supreme Court in a number of judgments has held that the provision, the rate of interest fixed by section 28 of the Land Acquisition Act 1894 is mandatory and the court has no discretion on the point. My lord, if your lordship can take...
But sir, that is a point.
Yes.
It is maybe a wrong exercise of jurisdiction. I may have overlooked a particular judgment or other consciously because it's a conscious decision.
No.
It may be contrary to law, but this is not.
Agreed.
That's a problem. That's a difficulty.
Agreed.
That's a
Agreed,
difficulty.
What your lordship is saying, but the conscious decision regarding is based on, if your lordship has read, is based on equity, and the
Yes.
equity is very clear. Now it seems, my lord, with all respect, that the learned my lord court did not consider the judgment of the Supreme Court, or maybe, with all respect, was not aware. And Supreme Court, my lord, in KG Deshra's case, Derasari case has said that if a judgment is passed without considering the judgment of the apex court, which is a law under Article 141 of the Constitution, then the review lies. That I can take a straight way, your lordship, to page 28, my lord. KG Deshraj of the compilation, my lord. My learned junior will give the compilation.
8.
Can you please send for my papers? Yes.
Page 28, my lord. KG Derasarai and others. This is 2001 10 SCC 496. If my lord will come to page 30, I'll take a straight way to the relevant paragraph 7, my lord.
Yes, sir.
My lord got it.
Yes, yes.
Having considered the rival submission at bar, we have no hesitation to come to the conclusion that the tribunal was not entitled in contempt proceeding to consider legality of its earlier order, which has reached finality, not being assailed or annulled by a competent forum. If the tribunal has not looked into any previous decision of this court, which is the law of the land by which it was bound, the remedy available to the aggrieved person was to file an application for review. So my review petition is based on this. And my lord, I may tell your lordships the facts of the case. My lord, the tribunal, the Central Administrative Tribunal, this is before my lord L. Chandrakumar case. The Central Administrative Tribunal, by order dated 17/1/1995, decided a service matter. And later on, my lord, when the order was not followed, a contempt was filed. In the contempt petition, my lord, it was discovered that there was already a judgment by Ernakulam bench, which was upheld by the Supreme Court. So that became the law of the land, and that was not considered.
No, we are entering into the merits of the matter, whether in the facts and circumstances of the case, the law that is according to you that it should be uniform or it should be the rate that's fixed by the Supreme Court or not, was followed or not. Now, a court has the power to pass an order according to its own discretion.
Absolutely.
And in this case, apparently it seems that His Lordship has taken into consideration the relevant provisions and the judgments also. And thereafter has arrived at a conclusion. Now that conclusion may be erroneous.
No, I'm not saying that.
The conclusion may be erroneous.
Yes,
But difficulty for the contempt, difficulty for the reviewing court, as you are aware of it, is very limited. It has to be error. Yes, so it has to be error apparent on the face of the record. So
yes,
this particular observation which is made, His Lordship has made it consciously, has given a reason. That reason may be correct, that reason may be wrong. But a reviewing court is not sitting in appeal over the judgment.
Absolutely.
There is a difficulty.
Well, my limited submission would be on the point, and law is very clear on the point, my lord. My limited submission would be, my lord, if the decision was considered by His Lordship.
But decision was cited, but that decision was cited.
No, it was not cited. Because I appeared, my lord, in that.
So if you have not cited a decision, there is the law is also, no, that law is also well settled, that just because you have not cited a decision, that would not be a ground for reviewing the order.
No, it's not be, because there was no occasion for me to cite, because we never thought that this will be passed on this ground. But what I'm saying is the court, my lord, it appears prima facie, with all respect, was not aware of the decisions of the Supreme Courts on the point. There are not one, there are 4, 5 decisions of the Supreme Court. And therefore, as an abundant caution, my lord, instead of going in for appeal, we thought that we will file a review petition before your lordship. Because that, if that decision was there and the decision was distinguished on the facts, that matter, then we would not have come before your lordship.
No, this particular paragraph 7 contemplates that if an order is passed without looking into the previous decision,
that's right.
The decision has to be brought to the notice of the court. That was not brought.
Yes.
So you want to say that the law on this point is well settled, and in the given facts and circumstances of the case, the award of interest would be at the rate fixed under the Act. That is what the statute provides for it.
Absolutely. And my lord, not only that, my lord, Supreme Court is very clear on the point that the court has no discretion. If I can, lordship permit me, I take your lordships with just one paragraph of 1997 judgment. That was page 31 of
Just give me one moment.
My lord may take page 31.
Page
31 of the compilation, 31. And the relevant is paragraph 13, 14, and 15, small paragraphs. I'll just place it before page 36. Relevant paragraphs are at page 36. I'm placing 13 first. It is intended that by operation of the proviso to section 28 of the Act, the claimant would be entitled to interest for 1 year from the date of taking possession at the rate of 9% per annum and for balance period at the rate of 15% per annum on the enhanced compensation. We find force in the contention. It is sought to be contended for the respondent that the reference court and the High Court have proceeded on the principle that the court has discretion to award the interest at the rate of 15% or less on the facts. The court and on the fact, the court found that 9% would be a reasonable rate of interest. We find that approach adopted by the reference court and the High Court is not correct, since the statute has given measures of assessment of interest for the first year at the rate of 9% from the date of taking possession, and on expiry thereof at the rate of 15% till date and deposit into the court on the enhanced compensation. It is legislative principle, and that the claimant would be entitled to rate of interest for the said period. Next page, paragraph 15. Under these circumstances, though the word may has been used in the proviso to section 28 of the Act, it has to be construed as shall, and therefore the claimant would be entitled to interest at the rate of 9% on enhanced compensation for 1 year, and thereafter 15% till date of deposit in the court.
Give me the land acquisition.
Then, my
Yes.
lord, if you lordship permit me, I place, my lord, another decision at page 17. That is BDA versus Mahendra Singh at page 17, my lord. Page 17. Madam, the citation is 2009 5 SCC 339. I think we have given copy to the other side. The lordship will come to page 19, my lord, 19. Similar view was expressed in the state of HP versus Dharamdas. It was held that when the statute provides for payment of interest to landowners,
Yes, sir. CPC. Yes.
a court has no power to award interest in the manner other than the one prescribed by the statute. It was specifically observed that there is no other provision empowering the court
Yes.
to
Yes.
award interest on the equitable ground, and equitable consideration has no role to play
Yes.
in determination of the compensation and the manner of awarding interest as enjoined under the Act. The same has to be administered in the manner laid down in the Act and in no other way. As a concomitance, the inquiry equity jurisdiction of the court is taken out, and the Act enjoins the court to grant interest as per statutory rate specified in the Act. The next page, paragraph 11, at page 20. A few small paragraphs I'll place before you.
Yes.
In D block Ashok number so and so, this court again observed that the liability to pay interest to the claimant arises only in accordance with section 34, as the Act is self-contained court. Common law principles of justice, equity, and good conscience cannot be extended in awarding interest contrary to or beyond the provision of the statute. Then paragraph 12, I will specially lay emphasis on it because it refers to 28. In the present case, it is the concern is section 28. Paragraph 12 at page 20 says, in view of what has been indicated above, the conclusion is irresistible
Yes.
that while exercising jurisdiction under 226 of the Constitution, there is no scope for direction to pay interest in the manner not contemplated under section 28 and section 24 of the Act. Therefore, my lord, my submission would be...
No, but please tell me, see, in a review, I have to come within the purview of the section.
Yes.
An erroneous decision is not open to review.
No, absolutely, absolutely.
So
You're
here
not-
it says, it may be an erroneous. It may be. Suppose it may be an erroneous in the sense that his lordship may have misconstrued section 34 or 28 or maybe some decision. But this is, see, this distinction between the appellate jurisdiction and the review jurisdiction. So here it has to be some mistake or error apparent on the face of the record. So this is not coming within, this is not coming within this, or for any other sub. Yes.
But that's very limited scope, Your Lordship has rightly pointed out. I can't go beyond that. But my submission, Your Lordship, will consider only this. That there is a law laid down by the
Just
Supreme
you are appearing for the.
Yes, sir.
But what he is said is in principle correct. Only thing I'm in review jurisdiction. That is the thing. But
My lord, there is another legal question that will open up, my lord, if your lordship entertains the review, my lord.
sorry.
Another legal question will open up if your lordship entertains the review, my lord. And that is, my lord, your lordship has seen section 28. If I may just read section 28, my lord, once again. It says, my lord, collector may be directed to pay interest on excess compensation if the sum which, in the opinion of the court, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. The award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date of which
To possession of the land.
position of the land, provided that the award of the
May
collector
also
may
direct.
also direct where such excess or any part thereof is paid into court after the date of expiry of a period of 1 year from the date of on which the position is taken, interest at the rate of 15%. So, my lord, there are two components,
9 and 15%.
9 and 15, but if not paid within 1 year. Now, my lord, what the learned trial court has done here, my lord, if I may take your lordship to the order part of the learned trial court, my lord. Your lordship kindly sees page 55 of the review petition, my lord.
Page 55 of the.
Review petition, my lord.
Is it part of the judgment?
Yes, my lord. It is part of the trial court judgment.
This is by the reference court, my lord.
The
Reference.
Just give me the papers.
Page 55 of the review petition, my lord.
We have annexed as annexure 1, my lord. Page 10. 10 of the.
Oh yes, we got it. Yes.
So, my lord will
Page
see
55.
my Roman 4, my lord. Then subpara B, my lord. On the amount to be paid, interest at the road rate.
Just give me one. 55. Yes. Yes.
What the trial court directed, my lord.
Yes.
At clause B, on the amount to be paid, interest at the rate of 9% shall be paid for the first year and 15% per annum on the remaining period for a period between the date of taking possession to date of payment. So the trial court has granted 9% and 15% now, my lord. Now, my lord, our case is that the trial court judgment, my lord, in this case, a few facts will be relevant, my lord. I'll just point out the land acquisition was of 2007, my lord.
Yes.
Land acquisition is of 2007. Reference courts, the trial court judgment is dated 20 February 24, my lord.
Yes.
So now the question is whether 15% interest is to be payable from which date, my lord? Because for us there was no occasion, my lord, to pay the enhanced amount. Here what happened, my lord, the collector is awarded 160 rupees per square feet.
No, normally when the compensation is awarded
My lord.
by the collector, so if you accept whatever the compensation, you
Right.
deposit the amount.
My lord.
If you don't accept this, you make a reference.
Yes, my lord.
It's open to both
Yes,
under section 18.
my lord. So they accepted under protest, my lord.
So under section 18, when you prefer,
My lord.
if you are aggrieved by the either of the parties,
My lord.
so normally the court says you deposit the amount.
Yes, my lord.
So that amount is deposited. That has to be calculated based on the compensation awarded by the collector. Now, once this process starts,
Well.
so the reference court will decide, and ultimately the reference court has to go by the statute.
Yes, my lord.
So the date that will be applicable, or that will determine the compensation of the two dates.
Yes, my
Date of taking actual physical possession when you
Yes, madam.
take the possession,
My lord.
for which 9% is there, and for the remaining period between the date of taking possession and date of payment.
Yes, my lord.
So once you make the payment to the, if you accept here, you accept the compensation amount. Once you deposit the amount,
Yes, my lord.
so this remaining period between, if it is not 15%, of course you will be entitled to 15%. So when ultimately it is to be compensated, you have deposited the amount before the reference court. So when ultimately the award is, if it is enhanced,
Yes, my lord.
then you have to pay that whatever the balance amount is on this,
Yes.
enhanced on that particular differential amount,
Yes.
15% interest. Because that is what the statute says so. Because that date of payment which you make before in terms of the section 18 reference, or other at the time when this was filed, does not contain the differential amount.
Yes.
That is why 15% on that differential amount.
Yes, my lord.
So what the learned counsel is saying is that this, while the learned single judge has upheld this award, but has make it 6% flat.
Yes.
Now that 6% flat is not permissible under section 28. That is a limited ground of review. The
Yeah, my lord.
question is this,
Yes, my lord.
whether
What-
this question
Yes, my lord.
I can decide the review or not.
My lord, what I was submitting, my lord, my submission to the lordship is that if your lordship entertains this present review petition, my lord, another legal question will open up, which is that's what I was trying to submit, my lord. That the statute says 9% for 1 year, my lord, and if it is not paid within 1 year, 15% interest has to be paid. Now, from which date? That is the question, my lord. Because possession was taken in 2007, my lord. Reference court judgment comes after 15 years, my lord, 2024. So can we be fastened with liability to pay 15% when the amount itself crystallized in 2024, my lord?
Now at the same time, looking from the other point of view, you enjoyed this amount. If you look from the other point of view,
My lord, this is
which
a penal
this amount which amount would have been otherwise payable, you utilize that amount.
My lord, 9%, I don't
It is just like your section 34 of the CPC. It is just like your section 34.
What I'm trying to say, there's a slide.
Pre-suit, there could be a discretion.
My lord.
But during the suit, statute says so. Post-suit, again the court says whatever the discretion is there, how much is the. But contractual rate till the decree is passed is retained.
So, my lord, I have two judgments of Allahabad High Court, my lord, exactly supporting my case, my lord. That the reference court passed judgment in 2024 in our case, my lord.
But that may not be required to be gone into because of the fact that here the difficulty as I am facing is that this was a conscious decision by the single judge. So this cannot be said to be an error apparent on the face of the record. That is where I am stuck.
My lord.
But normally the judgments are like this. You have to pay. It's not an answer for any of the acquiring authority that because you whatever you paid at that point of time is a short payment.
But, my lord,
It's a short payment.
My lord, the
So
legal-
you enjoyed this amount.
my lord, I enjoyed, I am liable to pay 9%, my lord. Penal-
9% from the date of 9% from the period between the date of taking possession
But
to
15%.
the date of payment.
15% is penal interest, my lord. Some sort of penal interest because I did not pay within 1 year. Maybe I am liable to pay 9%, my lord, throughout the period. But 15%, that is where I'm submitting, my lord, that this will open up a second question of law, my lord, and that is why your lordship will not entertain this review petition and ask them to file an appeal, my lord.
It will open a second question of law would not be a consideration for not entertaining a review.
My lord-
Because if we find a review, then it has to be heard afresh. The matter has to be heard afresh if we entertain the review on the ground of interest, on the ground of interest. So whether we'll allow a rehearing on the ground of interest or not, that is the only issue.
Yes.
Because what you are submitting is provided I allow the review petition, then this question of law will arise
Yes.
that whether how is to be segregated.
Yes.
But the first threshold which
Yes,
the learned senior counsel has to cross
My-
would be the decision of the learned single judge.
Yes.
Well, I'll pass my order.
Well,
Thank you.
But one more decision of the learned single judge of Guwahati High Court, if your lordship permit me, I'll just place it. On the point.
With all humility, I submit that
Well,
you see that I still remember what a very learned judge of the Calcutta High Court said when I was quite junior. So one counsel went there with 10 books and said that, my lord, I want to cite these judgments. Then the learned judge was presiding the bench. He said, Mr. Counsel, if it is there in the statute, it is there. If it is not in the statute, you cannot improve by a judgment. So what I learned from there is these are golden words. So this is, we interpret the statute, but the source of power would come from the statute, Mr. Counsel.
I quite understand that if I have understood my lord correctly, and very rightly your lordship has said, that review jurisdiction is a very limited jurisdiction.
Limited.
And if your lordship is of the view that this was a conscious decision, knowing that there is a Supreme Court decision which has interpreted Section 28 and not one, so many, and said that the court has no discretion to interfere with the rate of interest as provided under Section 28. Now, my lord, my only submission would be that if it was a conscious decision, yes, we have no option but to go to the Supreme Court. But I am saying that there is not even a whisper of either the provisions or any decision of the Supreme Court where the learned single judge panel has come to a finding that we have discretion in the matter because of the equity or because of the long time which has passed or elapsed in between. I don't find there. So on that limited thing, and my lord, relying on this Dera Sarai case of that tribunal, that before L. Chandra Kumar, the Central Administrative Tribunal, which says that the law laid down by the Supreme Court, if it is not considered, then review is the remedy. That at paragraph 7 at page 30. Only on that I could, my lord, rather file this review petition. Only on that. Just above placitum B at page 30. Just above placitum B at page 30. The first line. If tribunal has not looked into, page 30, paragraph 7, placitum B on the right side, just one line above. If the tribunal has not looked into any previous decision of this court, which is the law of the land by which it was bound, the remedy available to the aggrieved person was to file an application for review. Only on this I am before your lordship.
My lord, to add to this, my lord, I can submit off the record, my lord. When the matter was heard by the then Chief Justice, my lord, the view expressed in the court was that he'll reduce the compensation, my lord, but uphold the interest. But when the judgment was passed, the honorable judge felt the rate, my lord, reduced the interest. But it, in my understanding, it was a conscious decision.
That we should not say. That goes on something sometimes. You cannot say that you made this observation, then I could have said that you have made this and you have passed this order. Those are observations.
No, I'm not saying that. I'm only trying to say that it was a conscious decision of the honorable judge. Instead of reducing the compensation, reduce the interest.
My lord, at least it doesn't appear from the judgment under review that it was a conscious decision. And knowing that Supreme Court has laid down these laws which are binding on the High Court, this was passed. That I will not agree. There is nothing to suggest
there is a judgment of the federal court. This 1949 Federal Court judgment, page 36, where you will find that this is 1949 FCR 36 Federal Court judgment. This is Hari Shankar versus Anantnath Meter. Similar point came up for consideration. That the federal court said that the decision is erroneous in law is certainly no ground for ordering review. This is in 1949. You'll find it in the Federal Court Report, page 36. And why I'm giving you the reference, because similar matter came up for consideration before me, sitting with Justice Vishwarup Chaudhary. And it was a review of the bench that was presided by the former Chief Justice of the Meghalaya High Court also. So this equity and other things came up for consideration, and we considered all these aspects in that matter. I think it may be reported also. It's West Bengal Financial Corporation versus F. Kalan tie-up. So there I considered this aspect of the matter in some detail, and of course this FCR decision, which is, I think, has been consistently followed thereafter. So that is the difficulty that a reviewing court feels.
Now, my lord, there, if your lordship permit me, I will only say that Privy Council's decisions or Federal Court decisions, Privy Council will be above, are binding on the High Court, Privy Council decisions, but not on the Supreme Court. And here
No,
is
this is complete, absolutely. No, I'm saying the principle. I'm saying about the principle. I'm not saying these maybe at the highest some kind of persuasive. Of course, if the Supreme Court has decided, that's the end of the chapter. So no decision which is contrary to the Supreme Court decision can be of any assistance.
So here is the case, my lord, where the learned single judge, my lord, has exercised his power and exercised his discretion and granted, my lord, interest other than what is provided under Section 28, which, according to the Supreme Court judgment in Dera Sari case, is not correct, because the law laid down by the Supreme Court is a law under Article 141 of the Constitution. I need not repeat it, my lord. Your lordship knows.
Thank you. Thank you.
Not it's an education, my lord. To appear
No, thank you. Thank you.
the lordships.
I will pass the order.
Ma'am.
Thank
Deep.
you. Thank you. Talk to the chamber just. ये लेके चेम्बर में जाओ. It's fine. ये भी लेके जाएंगे. Thank you.